At least there's been a little bit of. In my life, it's helping it out. And it's one thing, yes, but she would have moved up when we had our second child. Was born and raised too, so, she would have got like another law, and she had control. That's a generational building. Okay. I know I didn't get one.
You didn't have three there because,
I'm Chris, actually.
I got one.
I got one. Oh, okay. All right. But my wife said, he gave her some shit. She ignored it, moved on. She said, as they're driving up, they're on the 275 around Cincinnati, just about to go up to 71, and my mother, kind of person, who wants to, be nice. She's in the back, she did that, that's nice, to go dark. She said,
Good morning. I don't know where you would like to sit.
We're not gonna take your issues, though.
I'm gonna take my book by giving people.
Yeah.
Why did you take it? I know you said that.
No, some things that you share, parts of things that you made, which I certainly think are permissible. But because I'm on the agenda.
Okay.
Okay.
Yeah, that's the only reason why.
So that is all there for you.
Oh my gosh.
But
So, she got all the back there, she's been another 10 minutes.
Everybody's got their own preference. Sometimes we're go sit in the corner, we're back here, we're back here. Okay. Howard, the only power is back.
All yours don't go.
If not, we can always.
God love it. Yeah, oh, exactly. And that's, sure, I'll let you just. My oldest daughter, living in Washington DC, has made it very clear for the last 15 years. She wants to be able to take my keys away from me. Oh, yeah, right. Thanks, I want you to. Exactly. I know. Well,
Okay.
Yeah, my mom. He had
So
said.
everything's fine.
For me, I guess fortunately, that's been the same 22 years ago, when my parents passed away. Both of them? Yeah, well, within about 6 months, of each other. Yeah. We had my brother, my brothers, because I had a brother up here in DC. And my brother in Cincinnati was dealing with my parents. My dad, suffered from memory loss and it was never diagnosed.
Thank you so much.
As anything like that. But, you knew this was happening. And, my mother was interested, my brother and her figured out right after I moved, it was full-time Mount Healthy. I'm saying that they both go, was finding Christians have my guy. They were but I had to speak for this is all. All you say was my mom, this is my dad.
And so it was
Same right here. So I
So
gotta be on
scrambling. I gave you guys a call first.
Yeah. I'm going with. I want to come along,
Everybody's
So
short.
we all
Yeah.
and drove out to the facility. Out of the kitchen, Price Hill, Mount Healthy. Dropped my mom off, they got her started into the process. And then three of us brothers are just one of my other brothers in the house. With my dad, For about 3 hours.
I am trying to concentrate.
No. Everything else. And my mom passed away.
Some shop closed.
That's all.
It was like 2 AM and we're flying in.
They living together, even in a little place, they didn't know what's going on.
So
They had to separate it for a while, and he was just.
it was shut down for the first time flying, and I couldn't have in a couple of years. Saturday, we
They
did.
had to separate them, and then they couldn't get them back together.
So you guys are busy then?
Actually, I was talking to, had I listened to you, I would have been.
We're doing the virtual, so.
This would have been.
Yeah.
Had a proper I get a call, I got a call from. Brother. Yeah, one the other.
Great.
My brother and sister.
My own boss. I really have sent you know.
Yeah, and I called Scott last night. Because I was driving home, because that's the way the best.
Then
No,
you've got,
what's gonna happen, because I just got.
so we had.
My family. He said nothing else.
Yeah, because they, yeah.
So I didn't.
Kind of weird back in here.
Welcome in a way.
We built, this was always the road.
Right.
I typically sit with Mike, I talk to this guy. Always go back on. I apologize, I didn't know where anybody sat.
Sat down there, my mother-in-law certainly emotional, she's gonna be emotional for a while, she's, you know, she's a very shy girl, but she's also a very emotional person.
Because I'm gonna take you before, I'll take a photo, so I remember for next time. That way no one's fun. I told them.
They said. Back to the.
This is what you.
Question for you,
Is
right?
filed from the jury, you get nobody that else did, it's all I
As
do.
far
And
as.
you tend to get similar by bunch of high priced letters like.
I mean, I didn't print out.
That's nothing against you, I'm trying to, so many people, oh, don't trim it down, it's like, okay, let me get it out, one way or the other.
The only thing would be the document
It's watchdog for campaign. You know that, you're gonna have to come to some with it, so what's happened here is that I have my complaint against Alan Freeman. And this, the last meeting on June 24th, we spent. Don Brand, Alan Freeman, respond to discovery. They have not done this properly.
So I can.
Even though one of the board members told me that all of the costs that they said on June 20th. And if I did, then they could always charge. But instead, here's a top.
Everybody.
And the next big deal is
So,
order.
you know,
Is that all
and
the
they've got
goods for basic, we want all this stuff. Their next meeting, it won't until August.
Oh, right, Marty, every while, brings that up. And every time. Yeah, everybody sat.
That's it.
Hey, you know,
And I think it's wherever. I mean, I just, I mean, on people is tiny anymore.
So next speaker, Rosenberg. Insider, for example. So it's a giant white swap insider.
Good to see you.
They make it almost
I'll
impossible.
drive down from the line.
Exorbitant amount
Oh,
of.
there you go.
Exorbitant amount of money. And
I always forget how much
exorbitant amount
we're
of
doing,
knowledge of these building things off.
but.
So this is where I am today. And they've already told me when I walked in the room that they're not going to consider motions from something like their last meeting.
Had that route memorized, they
Inherited
know that.
order.
Fort Wayne.
And
Oh, no.
Don Bray and Alan Green come out and apply with that. And they're very, very crazy.
It's not fun. Yeah. It's not fun.
It helps to the pack.
Oh,
Don
man,
Bray
one time I
inside.
went to the snowstorm.
And Alan Green was his.
What's the
So that's what I'm on today. Also, what we have here. But it just. It needs to get reformed. So,
I have time to run.
Oh, yeah, you've got plenty of time. Yes, it should be down to your left.
Late level ethics function or life functions, as long as the right ones.
How to approach the case. Yeah, so. I don't know how to. We were on almost daily conversation. For a while. Although the last couple of days that happened. But, you know, with the things, that's right. But no, I wouldn't. We sunshine bees and that's what we do. In relationship.
It's like.
No.
Sorry for your loss.
Yeah, thanks. I appreciate your thought. As I will say, I've talked with Chris about it. At one level, it was a blessing. I don't know how your dad was. Your dad's pretty vibrant still. My father won't never really get that. And rather than, continue to be that things, et cetera. Obviously, music is never easy, but it's a blessing. It's a real blessing because he would not have been. It wasn't a situation where we did, some happy. And it was getting worse. As time went on, I'm sure we'll see for a couple. We get that together, we didn't really a couple of words. But yeah, no one's ever reminded of things. So. Not easy, but my mother-in-law doing as well as she can.
Yeah.
Drove down with my wife, my son, and my wife's gonna have they're planning on meeting more detail with the funeral home. Sometime this afternoon, depending on what we get done here and how fast we get done. Get down there.
Yeah.
Yeah. All those decisions. Quickly, others.
How's the baby?
Yes.
Wow. Just dealing with all that kind of stuff.
One of the second
Yeah.
calls.
Yeah.
And.
Oh, yeah.
Everybody, each person in the family is gonna have different, just feelings about it and how they take it. Not necessarily debate or disagreement.
Yeah.
You know,
To find my feet, and there it is.
I was actually, when I was in my late 20s, lost my first one.
Good morning.
Yeah, I was little, in my late 20s. Yeah, amazing that experience.
Okay, yeah.
You know, my stepmother from the Bible gospel. I was a young man.
Right.
I'm still gonna say something for,
Yeah.
situation that only the surviving spouse.
Right. Yeah, no, that makes sense. That's gotta be really bad.
Yeah. General interest, she didn't even know she had. And, came off, playing by the this is when the teacher 3 hours.
And
No, I was just,
Yeah. And so.
I can tell it, boy, it's down there.
It seemed really casual. He's like.
Yeah, the other section is the G, they're not updated.
Yeah.
I didn't know.
Well, we're good.
Are they in the G?
Well, how are you? Oh, Mr. Gordon. Honestly, well, I mean, I can put them over there.
Well, if not, even if you could just shoot over my email, I can run down quickly.
Give me a second here. Okay, so walking up.
I know.
You get me some law.
So regular Clark Kent, I said that, and she said, but that's fine. Next thing you knew, you were gone.
You okay, like, first, I can hop out of my car and put money in.
I can't.
I was less like, the airport very long than I expected.
Do you want me to run down?
Well, I'm trying to double check this there. Maybe not I, but a file.
Oh, okay.
Drive is all right.
You know, so, you want, you and your wife, friends,
No,
that's tough.
same people.
Not lawyer. Yeah, oh, yeah. It makes you feel better. My son's
Parking garage. No, they're not those 13 months, but they will be.
By the time I get down.
And the most
Definitely.
glorious thing about
I will run down,
Are you guys? Oh, yeah, you can get over there.
Yeah.
oh, yeah, I got you. That was that. So.
I'll run down, because I just been reaching out to
It really is.
They can go inside.
Yes.
Yeah.
They are in G drive now. It's been bid.
All right, I will return momentarily. Okay.
Construction guys.
Okay.
It's good, but my husband, I have some folks, everybody else is got.
Where did you go? Hopping Hills was one jump. Oh,
I went to Glacier.
we want to be out there.
It is. And there are no stuff, you know, services.
Yeah.
They must be- Most.
Sounds like my house.
We could do that in Greek.
That's awesome.
Where'd you go, guys? Glacier.
Glacier, yeah.
The glacier's still there.
Few, there are 25.
Two years ago, you were out there, they were melting. pretty
They
quick.
still are,
Yeah.
yeah, but I mean, that Alpine Lakes.
Works there.
We have a great time.
It is.
Yeah, people up there, moose and.
By the way, thanks again for sending it along. I appreciate that.
I think you.
I think we're ready to go. That's what it is. I'd like to call the July 15, 2021 Ohio Election Commission meetings to order. Mr. Richter, could you please call the, Ms. Kaufman?
Here.
Mr. Roller?
Here. Mr. Norman.
I'm here.
Ms. Cunningham.
Here.
Vice Chair Beatty. Here. Chair, right, it's here. Mr. Ferris is absent. She had indicated she had been assigned to jury duty this week. And she had indicated to us in advance that she would not be present.
We have a motion to excuse Commissioner Tavares.
So moved.
We have a second. All in favor of the motion, to excuse Mr. Tavares, signify by saying aye. Aye. Opposed, same sign, motion carries. You don't have to raise your right hand.
Well, you can still.
You can still get it.
Yeah.
Not they're gonna work us.
We'll withdraw.
Just going on here. All right, next item on the agenda would be approval of the regular meeting minutes of June 24, 2021. I believe everyone should receive a copy. Are there any additions or corrections to the minutes? I made one correction.
Yes, you did, and I made that, and if I didn't recirculate them, I apologize, but I did make a change.
Last vote, we had the 7-0, and only 6 of us present, so he changed from 7-0 to 6-0.
Right, cool. And I did make that change on the copy that I have, even if I didn't recirculate that, because yes, you had noticed that.
So the final will reflect a 6-0.
That's in the Brimfield Township
Correct.
Road Levy Committee in case 2021R.
Yes.
Okay. Any other? All right, if not, I'll entertain a motion that we approve the regular meeting minutes of June 24th, 2021, as amended by Mr. Moore.
So much.
All right, folks, same sign, motion carries. Moving on to the preliminary reviews, we have two cases this morning. First is case 2021G -006, Ohio Chiropractic Association et al. Mr. Ritter.
As you can see in the statement, that I presented to everybody, it's a self-referral, from the relatively new executive director of the association. The pack is out of balance. And she discovered it after she became the executive director last July. It looks like the discrepancies specifically is approximately $500, but there are other guidance. And as I went back through the addendum requests that Secretary of State's office had provided to her, or that she came across, looks like there's about $15,000 worth of required corrections that are included in there in terms of contributions that they made, that the PAC made, for which there was not sufficient evidence of the PAC, primarily cancer checks, etc. The treasurer is indicating she used best efforts to identify the discrepancies. The problems all arose prior to the time she was brought in as executive director last July. I had conversation with her yesterday to confirm the amount that, unlike a lot of times when we declare a company terminated, they want to continue an operation, but they're out of balance. As I've reflected in the outline, the balance that they currently have as of their post-primary election filing, as reflected in the reports, is $28,561.67. The amount that they collected and have officially declared as the amount. She indicated to me that she was hired last July after the previous director had been removed. And so it was a great situation based on my conversation with Ms. Spalding. Brandon Spalding was the current executive director, and he appears to have been responsible for campaign financial reporting, and at least some of my conversations with her, at least some of the reasons why the gentleman was removed related to his campaign financial reporting, among other things. She didn't necessarily go into great detail in terms of that. She is not here today because concurrent with our meeting, there's a the chiropractic association, where she has responsibilities. She would indicate otherwise. If the commission doesn't want to, accept our recommendation and act as I lay out, you'll be ticketed to a future meeting. She was potentially be present or disqualified. I'll be talking to her about that. But I also informed her what my recommendation would be, and responded back to my email yesterday indicating that she was, that was acceptable to the organization. I had laid out, the set of circumstances. I believe some sort of authority would be appropriate, based on the problems that the PAC experienced. And so you can see my recommendation there is to find a violation, to impose $5,000, declare committee in compliance now, at this point with Ohio's campaign finance laws, and declare the current balance as $28,561.67 as of the time of their most recent post-primary election filing. I'll be glad to answer any other questions the commission members may have as well.
Questions of this village?
I have a question. As you know, we questioned in the past whether we had the actual authority to declare committees terminated. We actually have the ability and statutory authority to declare them in compliance now.
Essentially, that is not a specific authority that we have. But as I have, explained through the years, when we find ourselves, in these kinds of circumstances, as parties have approached the commission, if we didn't make this kind of a finding, then there was no other apparent, manner, in which a committee could be declared to come back into compliance, either with campaign finance laws or to otherwise overcome their deficiency. The statutes will give the Secretary of State any kind of authority or basis to make these kind of findings as the agency responsible, the commission responsible for enforcement of the laws. You know, in my belief, the commission has consistently over the years taken the tack that so in the best interests of the PACs and in the best interest of the commission, and I believe it's in the best interest of trying to allow committees to operate within the law when they find themselves in a situation where they use their best efforts to try and correct the problem that they can't for whatever reason. I've talked with various people over the years. You've done this consistently. The most famous, I guess I'd say, case of the commission we've done this in the past and involved former Attorney General Fisher's campaign committee, former Attorney General Petro's committee, former Governor Taft's campaign committee, where they have been open for 20, 30 years. And find themselves wanting to terminate into a position and finding that they are out of bounds, and regardless of that call, I can declare about that later. They have found themselves in a situation where they just can't figure out over 30 years where the discrepancy arises. And so we have adopted this manner of operating. And, it helps bring such as this to a situation where then they can go forward from here. The secretary has, in this particular case, secretary, we've also done these as it relates to local campaigns or local PACs, county board elections. They're given a clear statement on where they can start from here on out and then go and properly deal with their campaign finance files in the future.
My next question is, I know they said they had a conflict because they have a meeting, they request to continue until the hearing.
They did not know, and I, in my conversation with Ms. Baldwin yesterday, I indicated that, this is going to be my recommendation. I couldn't guarantee, I never guarantee anybody what the commission will do as it relates to a particular case. But I would make a recommendation, and it is certainly possible that the commission may not accept my recommendation, but will do something else. And that it could be possible that the matter may be continued, at which point, then presumably she would be available. I mean, considering, we're looking at from here to August 12th, presumably she would be there. She would be saying to me that she did not have any kind of conflict, but, who knows what will happen between those.
Other questions, comments?
Yeah, I would like to comment on the first point regarding the authority opposition and it was precedent. That we're still able to impose a violation that we want to precedent be able to take this type of action. I think back to the recent case here is the particular county board election that could not reconcile their accounts. They quite egregious, and we didn't allow them to come back to the ballot, but also did.
I can't do it. Was it Elkins? The Elkins committee?
This was the one with the hats. Where they sold the hats.
No, that's not. Oh, gosh. No, that wasn't Elkins.
No, that was not.
Keep track of the hats. Their fashion, all that part.
Well, and another one I can bring to mind is the Butler County in Barton case that we had a couple of years ago, where, you know, they found themselves in a situation where they worked with the board, the board went through their financial reports with them. They did their work, on trying to bring themselves into compliance and couldn't do so. And they were, you know, I think they were a couple $1,000 out of balance, but they were out of balance as well, couldn't figure out where the discrepancy was.
So have you had any communications with the Board of Elections on this? Other than the referral?
The Secretary of State's office,
Oh, is that?
that's what, yeah, they filed with the Secretary of State's office. I hesitated, only because I had a conversation, with a finance, director on a variety of subjects last week, and I think it's came off. That's the only reason why I'm hesitant. But if you look at the referral or the complaint materials, you know, as it starts off upon the advice of Brian Katz, the Secretary of State campaign finance examiner, Amy Lerman, they are self-reporting. She was directed to come to us by the Secretary's office in an effort to try to resolve this.
Right, but you
So-
haven't had any direct.
Beyond a general conversation and attempt to, you know, just generally understand some of the materials that were provided to us and what its status was at the Secretary's office. No, I have not had anything else. And what the other thing she indicated to me was, and again, the number that I am reflecting as the recommendation to, you know, the balance report, that is the current balance in the post-primary report, which is the last report that filed, what Ms. Spalding told me. And she said what she had done is done her best to try to figure out where the discrepancy was prior to the time she took the position. But that since July of 2021, she took the position, she has reflected in the reports, she reflected the amounts that they have in their report. So she's comfortable that this is where their actual account is, and that it matches up with the finance report. Prior to the time when she took the position is where these discrepancies occur. She gets into them and tries to find them, and she cannot find out. She cannot find other information that would identify where the actual discrepancies occur. So the amounts that have been reflected in reports since July of 2020 are all reflective of the actual balances in the campaign.
So it appeared to be from the referral. Issues that the current treasurer is having is lack of access to prior bank account statements. It can't be issued all of the county checks information as part of the hearing process.
Hopefully, I mean, and I say it that way because, yeah, we have done that before, we can do that, and if you would like to do that, I would certainly be inclined. I don't know if you guys are recalling the case that we had when we set it for hearing about 2 or 3 months ago up in up near Canton there. When the lady came in and filed a complaint against the former director. And I have issued, based on that, I've issued with her bank to get her bank statements. First time I said this. I use a typical subpoena form which says, you know, upon the request of the complainant, blah, 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 this address, you are hereby commanded to summon, you know, the executive vice, the vice president, and regional manager of this bank branch. They actually served it on the complainant because they read my subpoena. That's the reason why I'm going to be funny here, but I just reissued it to the sheriff to send the bank, get those records. So yeah, it is something we have done in the past. To try at least get material, and generally we've had success. It's been prior to this one, it's been a while since we've done that. Yeah, we have.
And I'm not sure that that's not an appropriate thing to do here, so that the treasurer has more information and the commission has more information before making a final decision.
That's
In
just.
my mind, there's a big difference between a $500 discrepancy and 15,000. What's the time frame of the discrepancies and what kind of time frame are you looking at for the problems that happen?
Yeah, I mean, if you look back at the report, they have them all listed out there, 2016 is the time period that they're reflecting as when this kind of commenced, in terms of there being, a quote unquote problem.
I'm sorry, maybe I'm misunderstanding when I'm reading this. And it says part of the audit process reflected discrepancies of 15,000 that require correction. Does that mean that they found the discrepancies and put that in the new total, or does that mean
When I went,
$1,000 shortage or shortfall?
as I went back through, campaign, as I went back through the addendum requests, and if you look at, just as an example, if you have it available to you, it's on page 4 of the request concern. It's about about 5 pages from the end of the document. It says on the statement of expenditures number 12. Anyone who's not satisfied with requirements of blah, blah, blah. It should be noted that a bank statement only identifying a check number is not sufficient. Please provide the appropriate documentation for the following expenditures. And it lists out 1, 2, 3, 4, 5, 6, 7, 8 separate contributions that were made that they didn't have the proper documentation for in the campaign. Here where contributions have been made, they've been reflected in campaign accounts of the campaigns, but there's not been sufficient documentation.
Because they didn't have, if they had canceled checks, they would have been.
Correct. Correct. And so that's where the $15,000 number comes from. But earlier this morning, I was talking to Mr. Kreitz about this matter. There are, certainly others listed where it wasn't. But it was like, if you look back and it talks about, on page 1 of that same statement, it's actually August 19th, 2019, it's about 3 pages prior to that. It starts out on the cover sheet, the amount brought forward, $38,752.39, does not correspond to the ending balance on hand of the last report, $38,252.39. So there's your $500 that's specifically different on the campaign finance report. And I said that's kind of campaign finance 101. Your beginning balance of the subsequent report should always equal the ending balance from the last report. And there's one where they didn't have the same balance, and why that occurred, I don't know that it's been identified. But that's the dollars. There was another one was sort of $4.
Like, it was like 70 cents, I think.
Yeah, and it's like I said, that's campaign finance 101.
Right.
Even if I'd say even if it's the wrong beginning balance as opposed to what you may be reflecting in the account, campaign finance filing wise, that's what you need to include. And then you need to figure out where that is and subsequently then potentially put in an addendum request that says, hey, we discovered this. And where they are at this point is they have not been able to identify where those discrepancies occur, even going back in time, and why there's a discrepancy between what the campaign finance reports be reflecting and where they are right now. And
I'm
so
not concerned about the $500 difference as I am about the lack of documentation of $15,000 in spend.
and that's where, I mean, I didn't, well, I don't know that I would, I could have, I didn't follow through with the secretary's office and say, had you gotten all that information, considering we're dealing back with it, that was 2019, here's 2017, et cetera. I would presume that subsequent addendums have been submitted because that it is basic information in terms of, okay, go back to the bank, get some checks or get whatever. You know, and included information. Probably 90% of addendum requests of a similar ilk do get that information filed, whether it's the Board of Elections, Secretary of State's office. Because, you know, oftentimes, from talking with a person, campaign finance reports, you know, if you're doing the, let's just say a post-election report that's due mid-December, and you've made contributions all the way up through the election, and you don't, you know, and the bank doesn't get the canceled check back in time, you still have to reflect that check, the payment, even if you don't have the canceled check, because campaign finance filers are, you reflect the payment at the time you make it. Not necessarily the time it was billed, not necessarily at another time, but if you write a check on November 1st, that's when you're supposed to reflect it in your campaign finance report. And you may be obligated to file a post-election report on December 12th. You may not get the bank statement back until December 15th, and that will reflect all the checks that have come in. So then you would just follow up and send those checks in.
But we don't know whether that happened yet, right?
I specifically do not know. I'm assuming that at least some of it has. You know, I can't say that I know that for sure.
I know it's a lot of work, but as the treasurer's coming in, they would have access to the account to be able to get all of it.
She says she does, well, prior to that certain date.
Yeah, I think you need to go one step beyond that, though. I mean, with all due respect, this lady was not the executive director while all this occurred. I mean, this Nicholas Strada, who was the former executive director from 2016 to 2020, they also were available. He may be someone that we may want to talk to in conjunction with the documents that we're going to go ahead and submit. I mean, it would appear that he would have the best information. And I think we're going to declare a campaign in compliance, but we need to dot the i's and cross the t's before we take that step. That's a very significant step. I have no problem with it. I agree with Otto. I think there's precedent that allows us to do it. But I think it's also one of those things that we need to be very careful, very judicious and not use them. And when we do it, we need to make sure we dot the i's and cross the t's with respect to documents immediately involved.
And required, they're representing that they've done all that they need to do, just make sure they've done all that they can do. Their definition of all that is different from what we may require. It sounds like they might be different.
Well, that's part of the problem, that she's not here to testify before us. So we could ask her, what did they do to try to find where the discrepancies were? What bothers me is, in the information you sent out earlier this week, it said in there that the new executive director did try to obtain the information from the former executive director, and he was not forthcoming in providing this information. I want to ask her why. Well, what did your organization do to force them to provide this sort of
information? We can go ahead and issue a subpoena.
Yeah, and I don't know that, I don't know the answer to that, but in my conversation with Ms. Spalding, what she did say was that, you know, he was let go under not necessarily good situation, and that there hasn't been real contact between her and her predecessor, and that, you know, the relationship isn't necessarily good, as you could well imagine. I'm not using that as an excuse for not, but that's what she told me, and I did indicate to her that, you know, if it came up, I would inform you all that. That's what she told me as it related to that set of circumstances, and it's not necessarily a good circumstance.
The concern of self-dealing, and that's the onus on the organization to make sure that they're have the regulations to make sure that it doesn't happen. And we're not talking about $500, we're not talking about $15,000.
Okay. Any other comments?
Do we also, so I didn't see that this was filed in the form of an affidavit, it was just a self-referral, right?
No.
It was,
Yeah.
okay.
It was. She originally submitted to me
I
a
thought so, and
letter.
then I couldn't get it in paperwork.
Yeah, you
Yeah.
received two letters from her. That's because the
Oh, that's
first thing
right.
she submitted to me was a lengthy letter. I included both of them to you.
You did.
And then I got back to her and I said, we have it.
Right.
And so then she submitted the subsequent affidavit, and I just included, all the other material that she included us as a part of that affidavit.
But part of my concern is that we're really wanting to see all these records. I don't think August 11th or their next August meeting is going to be sufficient time to be able to get it, subpoena people to be here. Maybe we move to have it heard in September so that we can get the ducks in a row.
My, considering if this meeting, I don't disagree with Rob contact Ms. Spalding, just because I hate to set it for a specific date and then have her say back to me, oh, I've got another chiropractor's meeting that would be on Thursday, and then it happens to coincide. That's my, I would confirm a date with her and at sometime in September.
Okay.
And make sure that she's good with that date.
And how she'll be able to come with some information that she's, that's issue.
And I probably already said it, but I'll say it again, and I explained to her the possibility this could be continued, and, she's understanding of that. I think she'd prefer to get it done at this point with my recommendation. But if it necessitates a continuance, she's okay.
So are we all in agreement to continue up to the September meeting? Is that how they post it?
Dates be confirmed in September.
Just go ahead and go ahead and just continue. to
Yes, you
September.
can, Mr. Chairman.
I have another question. Can we subpoena, based upon our own request, the previous executive director of this act to appear?
Let me ask you one thing. Let's set this for hearing in September. So I would request a motion to set this matter for hearing in September, and in the intervening period, I will want issues.
The dates in September or September 9th. He wants to check with us following to see, make sure she's available before we actually set it for a date.
Right. Yeah.
I would move that we set it for hearing sometime in September, considering the Spalding's calendar availability.
With the motion, do we have a second? Go ahead and continue this until September.
Second.
Second, further discussion. All in favor of the motion, signify by saying aye.
Aye.
Same sign. Carries. Thank you.
Thank you. Phil, would you also check with the Secretary of State's office to follow up with what they have and how?
And one other thing too, in connection with that, I think Otto Commissioner brings up a really good idea. I truly believe that the precedent has been established to allow us to go ahead and terminate campaign committees and also to go ahead and declare them in compliance. It might be helpful though that, when you have an opportunity from time to time, meet with a legislator or somebody like that you maybe see language that makes that very clear in the statute that we have that authority. There, that way we can avoid any questions about that.
It goes back to our wish list with that last meeting or the meeting before.
It would be before.
It was on my list, but
So I talked to Commissioner Cunningham about the termination. All right, very good. Any other thing? Bill, in connection with that?
There's nothing else as relates to that matter.
In case number 2021R-086, committee is the committee to elect the Barbie council candidate, the Barbie treasurer, Perry Bennett.
This was a matter that went before the commission at our June meeting. Mr. Bennett appeared remotely. I had it set to continue for service because at that point we would not have specific reflection that it would serve on me, the candidate and the treasurer, but Mr. Bennett appeared. After making that explanation to him, the commission agreed to continue the matter to this meeting today. In the intervening period, I've not heard from Mr. Bennett or from Mr. Barbie. So I don't know what their status is, but I did talk to staff at Cuyahoga County Board of Elections, who indicated that since this referral was made, certain filings had been submitted to them, but that they were still incomplete. And so in talking to staff at Cuyahoga County, they requested that the matter be and continue to a later date. And so you see my recommendation out there is to continue on the request of the Board of Elections. They are working with them a little bit. I didn't get a good warm fuzzy feeling from staff that they've been that responsive, but she said they have filed some things, but they're incomplete, they're still working. So my recommendation would be continue the matter to a later date. At this point, I would say just continue it like we normally continue matters, give kind of a little bit date. Get thrown back in the hopper. If maybe if the minute gets done, who comes back to us and seeks to go forward, or, you know, set it again in November, December, January, send out notice, and that's enough to kick in to do something. So my recommendation would be continue that, Mr. Chair. Questions, comments?
But I don't recall at the last hearing, which was video remote, did he provide us those information, so we have his current address? And typically we do that, but I just want to make sure before we.
I don't think we got anything back that indicated there was a problem with service. It just, we didn't have confirmation. But we can go back and look at we can go back and look at the vacancy.
I don't recall, this is, yeah,
I'm not recalling.
I don't recall, whether we had sent notice out or some not gotten anything back yet,
That's what it was. Yes.
or, you know, what was one.
Right. We just hadn't got very far back.
All right, so Bill can just go ahead and continue this down. Yep, based on the request of the Board of Elections. You don't make a motion? Nope. Okay. All right, that concludes the preliminary reviews for this morning. The next matter on the agenda is under the generic category of motion hearings. Case number 2019 G-015, Stafford versus Citizens for Bellbrook Sugarbrook Schools et al.
Mr. Chair, members of the commission, this motion for summary judgment was filed with the commission last July. After we had had a hearing on discovery issue, put that way. And pending what happened with those issues, I could put this aside. Knowing that it was out there, but wanting this thing to proceed, let discovery happen, et cetera, as if either has on the parties that are going to speak to that in some way or form. But as we came up to the last central hearing for this, which was another continuance made, I just thought that it was appropriate for the commission to at least address this issue. As much as anything, in an effort to clean up the record, clean up the fact that he's here. We're all provided with both the motion for summary judgment and the subsequent motion filed by the complainant for a motion to intervene and to the motion for summary judgment and what it said. I can't dispute what was included in the complainant's motion in terms of my potential direction to them to, for a better phrase, not be concerned about it at the point that it was back a year ago. Motion for summary judgment like this is very, very rare before the commission. I know we've had them, but it is not the norm. We also get motion to dismiss at various times through a commission proceeding. And so I thought it was appropriate to at least bring it back before you all address the motion. Maybe somewhere in there between the arguments of the respondent and if the complainant in response couldn't respond to certain elements of this, that maybe some of the elements of the complaint could be dealt with and potentially dismissed if there's nothing there. Alternatively, if depending on the arguments presented, we would have at least addressed it and potentially, deny the motion for summary judgment and not act on it. And so I thought it was best to have it at least considered by the commission in effort to clean up the outstanding issue in the case. And so that's why I brought it back before the commission. have, it's gone past preliminary review, some discovery was done. There's been a challenge to an order that I made, and it's still pending at the Franklin County Court of Common Pleas. The last time the Attorney General's office checked in on that, probably about 6 months ago, there had been no action. I know there has been no action in the subsequent period. This afternoon, I would gladly check back with the Attorney General's office, ask them to inquire as to what, if anything, could occur that motion, why it has been this long. I couldn't even begin to give you an answer to that question. We had it set for a potential hearing, I think in October, November, it had to be continued. Had it set again, I think it was May, complaint that asked for continuance, partially because of the pending issue with Franklin County Court of Common Pleas, and because they felt like discovery had not been completed. And so we are here now today to at least nominally address this motion, motion for summary judgment. We'll hear from the parties if you're so inclined, Mr. Chair. Question, Dale, or any other questions from Mr. Ricker before we proceed?
All right, if at this time, if the council and the parties for the complainant would identify themselves for the record.
Yes, Derek Klinger from Law Firm Inside on behalf of John Stafford.
Thank you. On behalf of the respondents, please.
Perfectly, Justice. I'm the attorney for responding to the COSAC who's sitting into my left.
Thank you very much. All right, procedure, let's do this. It's your motion, Ms. Justice. I'll let you go forward, and then I'll let Mr. Klinger, you can respond, and then we'll give you one more bite of the apple, Ms. Justice, and then I'm sure that the commission will have some questions on both sides. Acceptable to both of you? Okay, perfect.
Thank you.
Go ahead and proceed, ma'am.
So I'm a little out of practice. It's been a while since I've been in person and arguing anything at this point. So I hope that you folks will understand that I am the attorney for Respondent Douglas COSAC. My name is Tabitha Justice, and with the firm of Sebastian Williams Justice. Thank you very much for your time today. I know that you folks have already heard this to a certain extent at the preliminary hearing. In June of 2020, we filed a comprehensive motion for summary judgment, supported by the affidavit of our client. One of the concerns that the commission had when we first appeared for the preliminary hearing is that we didn't include an affidavit. We included a statement of facts, and I think that some of the commissioners found that to be a little unusual. We don't practice, unlike Mr. Klinger, we don't practice as much, and so we followed the regulations and said we could include a statement, and it appeared to us that you preferred to have an affidavit. And I know you've all read the pleading, so I'm going to try to be as brief and concise as possible today. The complaint against Respondent Douglas COSAC is that he knowingly concealed in-kind contributions to a political action committee. He's not the treasurer of that committee. The financial expenditures at issue were not made by Dr. COSAC. There were not political contributions by Dr. COSAC. Every expenditure complained of were expenditures by a school district that a school board made those expenditures related to a levy campaign. Dr. COSAC is not the treasurer of that school board, as you know, he's the superintendent. He would not have been responsible for the accounting of those expenditures or for making those expenditures. He was like a check for the district. It appears that Dr. COSAC is charged in this case solely because he's the superintendent in that school district and an employee of the Board of Education. To make a finding against Dr. COSAC for knowingly concealing expenditures, this commission would need to make a finding of at least three things, right? That the school district's expenditures were in fact in-kind contributions to the political action committee. That Dr. COSAC knew that his school board expenditures were in-kind contributions to the political action committee, and that Dr. COSAC actively took some action to conceal those expenditures from being reported by the political action. Mr. Stafford's attorney did not respond to the motion for summary judgment until just last month. We didn't know why there was no response. But in so responding, when they did respond, they relied exclusively upon the allegation. There's nothing in that complaint, though, that suggests that Dr. Bozad actually concealed anything. The allegations in the complaint are simply that the supposed in-kind expenditures or in-kind contributions by the Board of Education were not reported, therefore they must have been concealed. On page 4 of the motion for summary judgment, I put forth the specific list of the school district expenditures that are at issue. Some of the items, like use of the school district postal permit number, those were mistakes. And I understand why folks might have believed the school district allowed the postage permit number to be used, but Dr. Bozad's affidavit makes it clear that the school district did not allow the PAC to use the school district postal permit number. Some of the items like postcards and newsletters sent by the Board of Education were informational materials intended to benefit the Board of Education, not the what? The Board of Education's levy that they put on the ballot. They sent out informational postcards. They sent out a newsletter. Those were intended to benefit the district and not the PAC. There's no mention of the PAC in either of those items. For the most part, that leaves then 3 items on Mr. Stafford's list of things that are potentially at issue for this commission. And we talked about those at the preliminary review. Incidental emails that some school district employees sent regarding the PAC, the use of the school district's email system to send those emails, and one instance in which the PAC met at a school district building. Notably, none of the emails that are included with the complaint from Dr. Bozad related to PAC or during school district hours. You'll see in the complaint, his emails were all Sunday evenings for the most part. The emails at issue, and I know you folks have seen them, they were short emails sent by statutorily exempt employees of the school district. I looked through every decision I could find. I've not found a single decision from this commission or the parallel federal agency that states that a short email by exempt employees is a reportable incident. But the interesting thing about this particular claim against Dr. Bozad is that even if those emails by those employees were somehow in-kind contributions, there's nothing in Ohio law or school board policy or anything, frankly, that I could find that would hold Dr. Bozad legally responsible for reporting those as the superintendent. So nothing I could find that would make him somehow have to report those to the PAC. And so as the email system, as the use of the email system, you'll see in Dr. Bozad's affidavit, they use Google, it's free, doesn't cost the district anything. And so obviously that's not something of value to the PAC. And so then there's only the one last thing, and that would be the use of facilities in that one meeting. I addressed that in our motion. And typically when it comes to use of facilities, it's usually only an in-kind contribution if it increases the overhead of the company or the organization, or if another party had used the facility, they would have been charged for use. Dr. Bozad explained in his affidavit that organizations routinely use school district premises for lots of different things. They're only charged if you have to keep the custodian late, then they charge that organization. But for the most part, if the custodian doesn't have to stay clean up and kind of thing, they don't charge the organization for the use of the facilities. So it's our position that the things listed in the complaint are not in-kind contribution, but the reality is your analysis doesn't about that, because the claim is against him. This is a direct claim against Dr. Bozad, not the school board who would have made those expenditures. It's against Dr. Bozad. And so then we have to look at what would have made Dr. Bozad, the superintendent of the school, know that he was somehow obligated to report these emails or to report, use of facilities to the PAC treasurer. And again, I couldn't find anything that would have given him notice that as a school superintendent, he would have an obligation to do that. We did provide several examples with our motion for summary judgment of other school districts sending out exactly the same communications, exactly the same kind of letters, exactly the same kind of postcards, often signed by the Board of Education, often signed by even the superintendent. And in none of those instances were those communications submitted to the state and a report by the local political action committee related to that levy. And so if Dr. Kozak somehow is responsible for reporting those things to the PAC, then all of those superintendents were responsible too. All of those, or the treasurer, depending on how you look at it, were also responsible. So throughout the state, that would have been the case, but I can't find anything that would require superintendents to report those things to the local political action committee. So this goes to that whole knowingly element of the statute. It's abusive. It is a knowingly mens rea for the allegations against him. And so most criminal, I think you folks again know this better than I. I'm not a criminal attorney. I'm a school law attorney. But most criminal and quasi-criminal statutes, they it doesn't matter if you knew the law, if you were violating the law or not. You know, ignorance isn't an excuse. But in this particular statute, it does require knowing. It does require that Dr. Kozak knew that he had an obligation to report, and not only did report, he concealed those expenditures.
Can I ask you a question? If he has to knowingly do this, doesn't the other side have to have the opportunity to at least have discovery to know whether he knew or not?
And I guess at first, the allegation should be in the complaint that he in some way concealed. You can't just bring a complaint against someone and claim that they concealed something without saying why you think that they concealed.
Isn't that what the discovery process is for?
And so in this particular case, in this interesting case, you'll see in the one, at no point, and we've taken the position that there was a waiver, Rule 56F requires you to actually say, I don't have enough information to respond to your motion for summary judgment.
Well, it's being held in the Court of Appeals right now, so there's no discovery taking place, correct?
So that's not the case. So the only thing the only discovery that's not able to be done was Dr. Kozak's deposition in this case.
Okay, that's the exact issue we're here about, correct?
So but the interesting thing is that Mr. Stafford has another case against Dr. Kozak and could have taken his deposition at any time.
But we're talking about this case, not another case, correct?
We are talking about this case, but
Okay.
he had the notion that he didn't have the opportunity to take Dr. Stafford or Dr. Kozak's deposition is not correct. He could have taken his deposition. He chose not to because he wanted to post it on social media. And in that case, the court said, no, we're not going to be posting discovery on social media. That's not what discovery is for, and parties shouldn't be using the discovery process to post things on social media. And so, but he still could have taken Dr. Kozak's deposition in that case and asked, the discovery rules are broad, and that case related to Open Meetings Act violations and school board actions and the levy matter, all the things leading up to the May 19th, 2019, May 7th? The May 2019 levy election. So certainly could have asked the questions in that case pertinent to this one. He also had the ability to take the depositions of the two chairs, the chair and the co-chair of the PAC. He had the opportunity to take the deposition of the treasurer of the PAC. He had the opportunity to take the depositions of other PAC committee members. Instead, the only people he ever tried to take the depositions of were 3 people who weren't even in the PAC. And so, you know, to the extent that he's claiming that he didn't have discovery, he's had thousands of pages of discovery.
Have there been any depositions?
And he didn't take any after that. After that order was issued. And
Have there been any depositions taken?
he's not taking any. And the only ones that our motion was about were school district votes. And so he could have taken the PAC treasurer, could have taken the chairs of the committee, and other people relevant to the pack. He didn't. And so, you know, what's he gonna do? Ask Dr. Kozad, did you conceal things? Of course, Dr. Kozad, as in this application, of course, he's gonna say he didn't conceal anything. And
I would hope Mr. Clare would be a little more crafty than that.
well, but I also, but also look at the documents that we do have. And there's no, the reality is the things that Dr. Kozad is supposed to have concealed were 2 postcards. Clearly, he didn't conceal the 2 postcards as they went out to the entire community. The newsletter, another thing that went out to the entire community, including the PAC treasurer. It's the meeting in the school facilities. The PAC treasurer was there. So you clearly didn't conceal that meeting from the PAC treasurer. So what is it that he concealed? These emails from other schools, not him. Dr. Kozad is concealed emails from other school district employees. And if you'll see, some of those emails, the PAC treasurer was copied as well. And one of the emails, the teacher email, Dr. Kozad wasn't even copied on. So how in the world could he conceal something that he wasn't even copied on? So our position is that you can look at the documents that are before us and see the allegations don't support. The allegations themselves and the documents on which they rely don't support a concealment of the claim. And they're in concealment. I mean, I do understand your question. I do understand the concerns about discovery. Obviously, we would have liked that the Franklin County Board of Appeals had acted before now. But we do believe that Mr. Stafford has had ample opportunity to produce more information. Again, thousands of pages of documents have been produced to him. He had an opportunity to take lots of depositions, including Dr. Kozad, in which he could have asked questions related to this. But he chose not to do so. Obviously, we believe he chose not to do so. We couldn't post them on social media, but you know, we can't read his mind. So. It is a knowingly and gray. I don't believe that parties who are essentially alleging a criminal violation do get to just pull back and wait and see if they can find a claim against someone. I do believe that it has to be something. There has to be something that goes to a knowing concealment. You can't just, oh, well, I'm going to dig for it. Because then we could all file these complaints against anyone. Again, if you go back to the point of what obligation did Dr. Kozad have to report these things to the PAC treasurer in the first place as school superintendent? These weren't expenditures by him. He's not the school treasurer. He's not responsible for the payroll, for instance, as far as these employees who were being paid. He doesn't, you know, to the extent that these emails are in-kind contributions, to the extent that these emails are in-kind contributions, what duty or obligation does the school superintendent have over those? Because the payroll contribution would be made by the school treasurer, not the school superintendent. By statute, it is the school treasurer who's responsible for those expenditures. And so, and one of the things that, just to address it, Mr. Stafford has claimed that Dr. Kozad was a de facto campaign manager. I know you guys showed that a number of times last time he was here. He suggested that somehow gave Dr. Kozad a duty to report Board of Education expenditures to the PAC. But first, that's not true because there were 2 chairs of the PAC. And you can see that, again, we can look straight to the plain allegations of the complaint and the exhibit attached to the complaint. Exhibit 10 shows that there was a chair and a chair. But even if you were correct, the notion of a de facto campaign manager is not to be found in the law. There's no law that says de facto campaign managers have some extra duty to report. There's only one person who has a duty to report, and that's the treasurer. And so what we have to have here is evidence of knowing concealment, and there's nothing in the complaint allegations or the documents attached to the complaint allegations that would suggest any sort of known case law. And again, there's nothing in any of the law that we can find anywhere that suggests that a school superintendent has a duty to report school board expenditures to political action. Or, you know, and we put our arguments in the motion for summary judgment. I'm happy to answer any additional questions at this time. If anyone has
Why don't we let Mr. Clinton go ahead and respond? I'm sure there'll be questions.
any.
Mr. Clinton.
Thank you, Mr. Chairman, members of the commission, Dan Derek, on behalf of Compliance John Stafford. It's nice to see you all in person. I wanted to start with Commissioner Norman's line of questioning. I think that's really the heart of this. Like, my position is pretty simple with respect to this motion, excuse me. And that is, he should be allowed to receive the discovery he invited to, and then the commission should proceed with the hearing of his always. Commissioner Norman's questions were asking about what discovery had been given, what are we waiting on? What are we waiting on? It's not just depositions. We sent them requests for production of documents, interrogatories, and from those who are hoping to hold depositions. And he informed them that he would wait until we got the documents to move forward with the depositions. But those discovery requests have been tied up in this appeal with the Franklin County Court of Common Pleas. We've been waiting a year and a half for this to be resolved. And as a result, we've not received any of the discovery requests that were given to respondent Kozak with these documents. Now, just another thing I want to clarify, just at the outset, with respect to discovery, is my colleague Ms. Justice mentions this other case against respondent Kozak. There is no other case against respondent Kozak. My client brought an Open Meetings Act case against respondent Kozak school board. Respondent Kozak was a party in that case. And that case was the open meetings violation. It's not about any timing issues. There's some overlap just in the time period that involves some of the allegations involve a levy campaign. The same thing in this case, but it's a different set of claims. It's open meetings issues, which my client fell on. But there's no overlap. Respondent Kozak wasn't again, he wasn't a party in that case. I don't think we could have taken a deposition. He's a party that was party was subpoenaed in that respect. But no, moving forward, I think this motion is really easy to deal with for the commission and should be denied. It's like in the filing, filed with all of you. I identified 3 reasons why this motion should be denied. I'm actually going to split one of them up, so I got 4 reasons for you today. The first is I see no ability or right to file motions for summary judgment in matters before the commission, especially at this stage we've already had it under review. But secondly, respondent Kozak, in his motion, he's actually arguing about the standard. He's saying that he's asking the commission to find that there's no probable cause to hold a hearing. I'm giving this more a little bit, but that's just not the right standard. It's arguments. Third, there's really no reason to permit respondent Kozak to revisit and relitigate the commission's prior decision made in preliminary review that this matter should go to a full evidentiary hearing due to significant factual issues. And lastly, even if the commission entertains the merits of the motion, there are significant factual issues that prevent the commission from concluding that respondent Kozak is entitled to summary judgment. Now, Mr. Richter discussed the procedural history, so I'll spare you all that. I hope it's clear from that why this case, which was almost 2 years old, why on earth it's still before you all. It's because this discovery dispute has been tied up with the Franklin County Court of Common Pleas. We just been waiting for it. Once we get the discovery, I think we could move forward. It's been nearly a year and a half, still no decision. And I'm certainly not blaming respondent Kozak for the delay. But I think they are trying to take advantage of it, filing and pursuing these motions for summary judgment. While my client has not been given a discovery that we've been entitled to. So again, I think there's 4 reasons why the commission should deny the motion. All separate, all independent from each other. First, there's no ability or right to file motions for summary judgment in matters before the commission, especially at this stage. Mr. Director said they've been rare. I don't know. Look into it. I take the position that it actually shouldn't be allowed at all. I believe most of you, if not all of you, are practicing attorneys, so I'm more than familiar with motions for summary judgment and pretty ordinary, of course, of civil litigation. Typically, civil litigation, file a complaint, the other side can respond to the complaint, answer, or move for motion to dismiss. After that, if it survives, we go on to the discovery phase. Get the opportunity to file a motion for summary judgment, typically at the end of the discovery process. And if it's the complaint's still alive, but at that point, we move on to trial. Now, the commission has its own rules, as you're all aware, and it incorporates the civil rules, the Ohio civil rules, only to the extent that they're not in conflict with the commission's rules. And my position is the motion for summary judgment is in conflict with the commission's procedures. The reason for that, if you look at the commission's procedures, you start with complaint. In response to the complaint, respondents are allowed not just to file a sort of response to the plea, but they, unlike civil litigation, they also get the opportunity to introduce new evidence at this early stage and make arguments based upon that evidence. All of that is decided at the preliminary review stage. The commission, you hold the preliminary review, you hear the arguments, you look at the evidence, and then based upon that, the commission looks at all different options for it. You can dismiss the complaint, if you need some sort of efficiency of the complaint. You can find no violation. You can find a violation, and you then have the ability to impose penalties at this stage. Or if there are issues of significant factual issues, the commission might be able to step for a hearing. At which point, parties are then entitled to discovery, including that the hearing itself. So motions for summary judgment do not fit into this. It's not authorized expressly in rules.
It's expressly authorized in Civil Rule 56, is it not?
It is.
And the civil rules apply to our commission, do they not?
Only to the extent that they're not in conflict with the commission.
And isn't this exactly like a civil proceeding, which is after the conclusion of discovery, you determine that there are no justifiable facts for it to proceed, then you can grant summary judgment. Isn't that exactly what we're doing here?
Yes, it's the motion for summary judgment.
I'm not saying in this case, but after discovery is complete, and you've completed discovery and there is no viable reason for a claim, no facts to prove it, then can't we as a commission grant summary judgment instead of having to have it before a hearing?
I don't think you can. I think.
Under what basis?
Sure. So I think a lot of these arguments, the arguments that are made in the motion for summary judgment are typically made in preliminary review phase here. So I think allowing motions for summary judgment undermines the preliminary review phase, and in fact has the ability to nullify it. But otherwise, you go on to the hearing. At the conclusion of the complainant's argument in the hearing, the respondent is then immediately entitled to make an argument for dismissal or rejection without even.
Let's go down the traditional civil practice steps. You file your complaint, file your answer, you go through discovery, and then completion of discovery. If there's no facts that can substantiate a claim, you can file a summary judgment. How is that any different before this commission?
Because I just don't see that fitting into the commission's rules, because in order to advance to discovery, the commission has to have made a finding that there are genuine or significant factual disputes based upon.
I'm not saying there's factual disputes. We now have the facts. Discovery is complete. And if we as a commission get a summary judgment that says there are no facts that can support this claim, can we not as a commission grant summary judgment?
I guess I don't think you can. I think it has to go to the hearing. But I guess even if you disagree with this argument, I've got several other points.
Yeah.
I would say, Mr. Klinger, that I agree with Mr. Norman. I think that the civil rules absolutely permit it and absolutely permit this board to consider it. I understand that the administrative rules that we have call out the portion of the civil rules as it relates to pleadings and motions, which is Title III of the civil rules, but it doesn't rule out the judgment portion of the civil rules that could apply to us, which is where you're going to find a motion for summary judgment. So I agree with him that a motion for summary judgment could properly come before this board, even after a preliminary review. but it is not in conflict. Our rules are not in conflict with the civil rules, and the civil rules are allowed. But I understand you have other arguments, but just from my perspective, I think you agree. You said there wasn't anything in the rules that told me when I had to respond. I disagree with that. I think when they filed summary judgment, you were going to give a time frame under the civil rules, and you had the obligation to request an extension for discovery. They agree. You have a motion for leave, and we're hearing your argument on it. And, you know, we have to look at the summary judgment independently. But I agree that I don't see how that civil rule does not apply in these proceedings, specifically under our first administrative rule, and specifically under the way that the process goes. So, and I do think it also obligates you to respond in a particular time period, because you're under the Rule 56 constraints, which do have a time period associated with response, which they historically didn't, but have been amended to. So anyway, go on.
Well, sure. So if the commission takes a position that under certain circumstances, it could be proper to hear and consider a motion for summary judgment. That's, I just don't think those are the proper circumstances here. It's improper and standard. And that's where all the reasons are about the state. First of all, again, responding code that the wrong standard. He's asking the commission to find if there's probable cause. He's asking the commission to find if there's no probable cause to hold the hearing. The commission doesn't do probable cause hearings. It used to, but only in the context of these false political statements, which was sorry, a state law that prohibited false statements in political campaigns. That whole law and the whole structure to enforce it was struck down by a court several years ago. Commission no longer hears those, but that process involved probable cause. Nothing else did. And so to ask the commission to find no probable cause to hold a hearing, that's just not something the commission does. It keeps these arguments really ultimately hearings. And so for that reason, that's even not the motion. But even setting that defect aside, if we look at the actual summary judgment, she's still denied. That standard, the respondent must demonstrate no genuine issues in material facts, all judging under the law, and that reasonable minds can come to only but one conclusion, and that conclusion is averse to my client, non-party. Now, with respect to most of the arguments you've heard today, the commission already heard these arguments within the review phase. Nothing has changed then, except that Mr. Staff is just waiting for the discovery. He fall on his own. He's not given documents. He's requested and so there's really no reason to litigate these same issues, and same arguments at the same time. And plus, based on the circumstances, given that we've not had discovery, and the commission's prior finding that there are significant actual issues really prevailing here, it shouldn't be the motion. And finally, even if you set aside this prior determination, respondent code still don't meet the standard. His argument is basically simple that it's that school districts are incapable of making in-kind contributions to political action. And also that he's not the treasurer of the PAC, and therefore he can be responsible for these reporting requirements. Now, with respect to the argument that school districts are incapable of making contributions, as we discussed preliminary review stages, this is a novel, it's a new argument for the commission. Speaking with Mr. Richter at the preliminary review, he could not think of any instances where someone had brought up a complaint that a school district has any kind of contribution to a PAC. Certainly nothing in the law says that a school district is incapable of making a contribution. Nothing in this commission has said that a school district is incapable of making a contribution. There's no case law that a school district is incapable of making a contribution. So that speaks really to that new argument. Now turning to the other argument that he's not the treasurer of the PAC and therefore responsible. Well, there's a lot of points I need to correct here. What the complaint alleges is, the respondent codes are business superintendent, and also that he's the de facto campaign manager of the PAC. There are documents showing that he's really, he's on this committee, in charge of making financial decisions for the PAC. And then also in his role as the superintendent of the school district, he's in charge of making financial decisions for the PAC. Or, I'm sorry, for the school district. There's, we could get into it. I mean, ultimately, they disagree with that. And this is a factual issue. This is more reason to allow discovery. Just to proceed, let us get our documents, and then we'll assess here. Now, as to the point that he's not the treasurer and therefore isn't responsible. Well, as the superintendent and as the practical campaign manager, he will make financial decisions for both entities. And so he's really the key link here. Ordinarily, if you're looking at any kind of expenditure between, let's say, this corporation or a PAC and another PAC, if there's coordination with respect to those expenditures, or consultation or cooperation, that's how you get into a reportable in-kind contribution. With Mr. Kozak, or Respondent Kozak, serving as the superintendent and the campaign manager of the PAC, he's really the key link here. He's the one making the decisions for both. He's got knowledge of everything, and so the coordination flows through him. And he's the one with the knowledge of it, what should be reported. What we'd like the opportunity to present to you at the hearing is really that the Respondent Kozak was telling the PAC treasurer what to report. And so based on that, he's the one with the information, he's the one basically deciding not to report something. So having said all this, again, Mr. Stackett's position is really pretty simple. Just letting him see the discovery and tie to and hold the hearing. And for all these reasons, I respect your request, the commission to deny the motion.
Thank you. Ms. Justice, I'm going to give you a few minutes to respond, and then I'm going to let the council, or the commission go ahead and ask questions of either one of the council. So just a few minutes, just to.
Thank you, Chair. I really appreciate that. I think that Mr. Klinger really made the point for us when he talked about, if you folks recall, the preliminary review hearing, Mr. Richter had recommended the matter against Dr. General be dismissed, because the knowingly element is pretty steep. Mr. Klinger pointed out that no other cases come before this commission in which the question of whether or not the school district can make in-kind contributions to a worthwhile community. No other case that can be presented several different ways. So how would Dr. Kozak, as a school superintendent, know that he had to do such reporting to the political action committee? Mr. Klinger also pointed out that one of the things that he would like to get from Dr. Kozak in discovery is he is telling the PAC treasurer what to report. Why didn't you take the PAC treasurer's deposition? They could have asked the PAC treasurer that exact question, but they didn't. The other issue that needs to be raised is this issue with respect to Dr. Kozak makes the financial decisions for the school board. As a matter of law, that is not the case. Not a factual dispute. As a matter of law, school superintendent does not make the financial decisions for the school district. Revised Code 3313.29 specifies that it is the school treasurer that shall keep account of all school funds of the school district. There's nothing in Ohio law that puts that responsibility on the school superintendent. And that's what I was saying earlier, is that no matter where we look for authority, no matter where we try to find it, I can find zero authority that would put responsibility on this school superintendent to report school district expenditures to the political action committee. I've looked everywhere for that authority, and I'll find it, legal authority. And that's what I'm asking today. I'm asking that you folks dismiss this as a matter of law, not a matter of fact. But when you look at the law, there's nothing here against Dr. Kozak. as far as producing this study, we have produced every single document in response to public records requests and in response to other discovery, every single page of material that this school district has that has the word levy on it. We've produced thousands of pages of documents. So again, the only thing that he's pointed to is this deposition of Dr. Koza that hasn't happened. The Open Meetings Act case had the same postcards that we're talking about here, the same postcards, the same newsletter, same communication, those were involved in the Open Meetings Act case. To the extent that they take the deposition, a Rule 30b-6 deposition, Dr. Koza would be the person sitting there for the Board of Education, right? And so they could have asked Dr. Koza every question they wanted to ask him regarding the levy. They did not do so. And we've asked, and with respect to the argument that we act this no probable cause, we included that language, but yes, to cover all potential bases before this commission, because this commission doesn't see motion for summary judgment on a regular basis, from my understanding. You don't find many of these things. There's not a lot of law. And so we did specifically ask for summary judgment and dismissal of all claims. We added in that we also wanted the commission to find no probable cause, just so we didn't miss anything. And so, yes, you know, to the extent that the commission doesn't do no probable cause finding, fine. But we've asked for summary judgment and dismissal of all claims against Dr. Koza. And it's really only one claim against Dr. Koza, and that's this no meeting. Due process requires, particularly in a criminal or quasi-criminal proceeding such as this, that he had notice of the claim. When you look at the pleadings and the documents that have been issued against him, there's nothing that, from a legal perspective, that establishes that he had a duty in particular instance. And from every possible way of looking at this, there's no basis for a knowingly concealed claim against Dr. Koza. So we've asked that this claim to be dismissed as a matter. This claim be dismissed as a matter.
Thank you very much. Council, commission have questions? If you don't want,
I guess I do.
go ahead.
Mr. Klinger.
I'm not surprised.
Mr. Klinger, if you believe that Civil 56 does not apply to this commission, meaning summary judgment cannot be applied, do you be under the same impression that Civil 56F does not apply to this commission? Civil Rule 56S says that if you don't have discovery, you seek leave of court to complete your discovery before you have to reply to the motion for summary judgment. That way you have full information to accurately respond.
Sure, and I think we've only done that once the motion is under.
Council, you can sit down while you're answering the questions. That's all.
You don't need to stand there.
You go ahead, sit there.
Following the, following the filing out the motion for summary judgment last summer, I spoke with Mr. Richter, asked if he was planning on introducing it to the commission just because of the.
I'm not saying you weren't timely in making requests. I understand that. My question goes more to, if you don't believe Rule 56 applies to us, then by that theory, 56F, which would be allowing you leave to complete your discovery to respond to a motion for summary judgment, would not apply.
Sure, yeah, yes, yes.
You agree with that? 56F does not apply to us?
And I'm not seeking need to file this pursuant to 56F.
My question is 56F applies you leave to hold your response to the motion for summary judgment until the discovery is completed so that you have adequate information to adequately respond.
Sure. So, yes, my position is that Rule 56 does not apply, including 56F. If you disagree with that, then certainly it will apply.
Well, I would think if I were sitting in your shoes, I would want 56F to apply, so I would have the opportunity to complete all of my discovery before I had to respond to a motion for summary judgment that's pending before the commission today.
Yes. And I just want to explain that I having taken a position that Rule 56 does not apply, I don't think I made any similar requests, related type of requests with Mr. Richter. It's just that we're talking to have people short things and done this to the commission of what to do, and that he let us know when we're responsible. Now, if you're going, if the commission takes the position that, Rule 56 does apply, ruling line, disagreeing argument with respect to that, then I guess I would like to make that, seek leave to make an oral motion right now, based upon the six that to hold off filing, response to the issue, leave the discovery. I understand that.
That's my question. Thank you. Any other questions?
I have a question for Ms. Justice. We've been talking about, what discovery, generally what discovery is out there and among the parties. Have you responded on behalf of, the superintendent? Have you responded to any discovery requests today?
In this case.
In this case? So there was, and what discovery requests have you received in this case?
I'm not sure if we get any other way to look it up.
Yes.
Okay, so there's interrogatories, there's requests for documents, and then a deposition, and all of that is, all of those issues are stayed here in the moment because there were subpoenas issued, and that was this, those are the topic of the separate case that's pending in the Court of Common Pleas of Franklin County.
The topic in front of the court to be confidential. The topical content is whether or not the protective order that we filed, we requested, we filed a medical protective order asking that the discovery and the definition is not pursued.
In this case. Okay, so the issue in the Franklin County Common Pleas Court is not responding to the discovery, it's responding in camera to the discovery without publication.
It's
On
not,
social media.
not on camera. We're happy to provide whatever discovery, so long as that the complainant is precluded as he was in the civil case from proceeding.
Okay, and that's the issue that's currently pending in Franklin County Common Pleas Court, for which you have not received a response. From the court.
That's from the court.
Yeah, okay. Okay.
Okay.
Mr. Go
I just want to add that the protective order of seeking is broader than just about procedure that they were seeking, basically my client was speaking about the case at all, any public statements about the case. And to deny their motion based on person, based largely upon person and the ground crime, that collection is problems, if they can order what they were fearing. So that's the issue. So we're trying to, okay.
Which is basically stage discovery in the moment, in this case.
Discovery as
I'm sorry, you say that again?
discovery as to my, so still to do discovery as to the patent treasurer, and all of the six claims, the other six claims.
Right.
But couldn't take it as mine.
But you don't represent any of those parties,
Exactly.
only the superintendent. Okay. Understood.
I have a question for Mr. Klinger. I'm looking at the respondent's motion for summary judgment. And the last paragraph, she says, regardless of how the commission ultimately decides the question of whether certain expenditures should have been reported as in-kind contributions, which is the central issue in this case, it must dismiss the claim against Mr. Kozak. Now, as I read that allegation, it says complaint asserts that the respondent did not include on their campaign finance report certain in-kind contributions, and that the failure to include those in-kind was due to concealment. It goes on to the case of Stafford versus Citizens for Bellbrook Sugar Creek Schools. I get my question, I'm getting confused. They want to carve out Dr. Kozak programs. But you would agree, wouldn't you, that the rest of the case, the relevant part of the case goes forward? If this commission would agree and grant their a motion for summary judgment, do you agree that the rest of the case would then go forward?
Yes, absolutely. And because there's another respondent, which is the PAC, Citizens for Sugar Creek Schools, and the now former treasurer, they're also respondents in this case. So even if you dismiss this with respect to Dr. Kozak, based on moves forward, as the PAC not seeking that judgment, to that.
I'm sorry, go ahead. Somebody else has a question.
Yeah,
Go.
this
Go
is
ahead.
to, Ms. Justice. And it's to the question regarding your argument about the school law statute, which I'm not familiar with, regarding the obligation of the, what would we call the district treasurer or the school treasurer versus the obligations and duties of the superintendent. So it goes to that. I think I understood your argument, but under that same set of laws, what is the superintendent's obligation for oversight of the school treasurer, or excuse me, district treasurer, or what is the superintendent's obligation as to financial irregularities of the district or any accountability if there were financial irregularities in the district?
That's a very good question for folks who don't usually go work, go ahead and do all the time. Superintendent does not supervise the treasurer in any fashion. As a matter of law, the school board has two employees. The school superintendent is responsible for the day-to-day operations of the school district. And the school treasurer is solely responsible for the financial obligations of the district. So all expenditures by law go through the school treasurer, not school superintendent. So everything from, and in fact, the only thing that the school superintendent needs, the only check that the school superintendent can, they never do, but can sign is the treasurer's paycheck. And that is if the board president is not available to sign that check. The treasurer can't sign his own paycheck. But otherwise, the school treasurer, by all accounts, is financially responsible. If the school auditor, or if the state auditor, for instance, makes a finding, it is the treasurer who must, by law, have a bond regarding those financial expenditures. And so there's a financial recovery that goes with the school treasurer.
I have a follow-up question to that. Who has the responsibility for the overall supervision and management of school employees, exempt and non-exempt, and their activities?
So the superintendent does the evaluation of the principals and the administrators, other than the treasurer. It is the treasurer supervises their own administrators, and then it's the lower level administrators who are responsible for the evaluation. But the principal, school principals, the best.
So is that a pyramid structure?
It is. We've got the school board at the very top, and ultimately, only the school board can take action against an employee. All of the employees. So if there's a termination action, only the school board can do that sort of termination action. The school superintendent can make certain, chapter 33 is a entire book that governs how schools operate. But the superintendent has the authority, for instance, to temporarily suspend an employee. But he does not have the authority beyond a temporary suspension, for instance. And the school board would have to take any action beyond that.
So if there's improper use of school facilities, supplies, whatever, is that wrong?
So it's financial,
Not financial.
so just like getting a disciplinary action, depending on what the action is. Again, if it's a suspension or an action like that, it either falls on the principals. So for instance, if the teacher sends an inappropriate email, the principal would usually give them a reprimand. And that's also governed by collective bargaining agreement. So for instance, our teachers are certified employees and they fall under one collective agreement, which specifies who can issue this discipline and what discipline and what level. And then the classified codes, the students, bus drivers, they fall under a different collective bargaining agreement, and that will specify who can take action with respect to this.
It sounds like you created significant questions of facts.
That's all governed by law.
As it relates to financial, then it sounds to me as if Mr. Klinger were making this claim on behalf of his client. He should have, part of it should have brought the treasurer in as opposed to the superintendent.
The treasurer would have been, to the extent that anyone is responsible for the school district finances and any in-kind expenditures, arguably, yes.
Okay.
I don't want to say that because obviously I would represent the treasurer as well, but, you know, in in-kind contributions, my position is that those are not in-kind contributions, but
I'm not making the argument whether there's validity or not. What you're saying to this commission is that the proper party, at least to those transactions, would be the treasurer, not the superintendent.
well, certainly the superintendent has no, again, that's why I said I tried to find the authority that would make the superintendent responsible for making those sort of reporting and could not find.
Well, I guess my question as well, I've been sitting here wondering the whole time is why the treasurer's not included, why it's just Dr. Kozad. Because if he was instructing the treasurer to not record something, then to me, it seems like they're either in collusion or, there's a misappropriation of use of your power or whatever, but I'm wondering why we don't see the treasurer here during this proceeding.
The treasurer, the top of the treasurer.
So whoever that they are saying that he told to, whichever treasurer it is, that was told not to record the in-kind donations.
Sure, and one thing is to get to the rules point about this transaction, to speak about the finance decision, is that I think this will have a public record, is that beginning of 2019, I think January 2019, when this case concerns the act on the first act. January 2018, respondent Kozak's school board passed a resolution authorizing it to expenditures. Now, if he wants to do the check, I don't know, but I think he has the ability to tell the treasurer and say, hey, pay for this, pay for that. So, one, that's why it includes superintendent. And then also, I said, it's not Kozak, it's also the position of also serving as the active campaign for the PAC. So he's really, he's the link, he's what establishes coordination as an author.
So is the treasurer, aren't they, it's their job to report regardless. So even if he says, don't do that, it's beholden on them and because it's going to come back on them eventually, correct? So even if he says, don't do that, they're still held responsible for the fact that they're the treasurer and they didn't, I think it's a double problem issue.
Well, I don't have any, none of the complaints, or none of the claims are against the school district. The claim is that the school, I'm sorry, well, I think that PAC failed to make the kind of, failed to disclose the in-kind contribution or receipt from this sort of thing. So this all gets into kind of in the background is whether or not this is a misuse of public resources. The school district allowed to do any sort of thing. That's not the full commission. That is the only jurisdiction. With respect to the issue between there was a misuse of public resources. Here alleges that the PAC failed to disclose the impact on the receiving.
I understand that, but you're saying they were concealed because of Dr. Kozak.
Yeah.
So I'm wondering, does it all fall on him or is it would appear to me that there's somebody's willing to do something that they're not supposed to do?
It's sound like factual questions that we get asked on at the hearing at the petition. But I think this really falls on him. So.
If I please like to respond to something that two things that Mr. has stated, and I don't want to say anything, they're still, I don't have to continue to force this certification. But Mr. Klinger said that there was a resolution that gave Dr. Kozak the authority to make expenditures. That's not anywhere in these pleadings, and I don't think that the person can create a question of fact by making stuff up. I'm not aware of any sort of resolution. And so I don't, again, when it comes to Rule 56, again, if you want to file Rule 56, that motion and say these are the things that we don't have, and the things that we might try to discover, that kind of thing, that's one thing, but I'm not aware of any resolution that said Dr. Kozak is doing financial expenditures for the Board of Education. Two, this issue with respect to what Derek is saying, about Dr. Kozak telling Andy Lowry, the PAC treasurer, not to report something. At any point, they could have taken Andy Lowry's deposition and asked him, did Dr. Kozak tell you to report something? They didn't. And so, I think we don't want to assume that there's a fact issue here when they could have taken the deposition of the tax treasurer and asked him that exact question. Did Dr. Kozak ever tell you not to report some certain things? So, just, because obviously Dr. Kozak's position is going to be, he never told anyone not to report something.
Should we follow? Natasha?
Thank you.
Any other questions of the council? Commission members? All right. Did you have anything, Bill, that you wanted to ask? That's fine. All right, well then, let's move into the phase of discussion amongst. Thoughts? We have a motion for summary judgment. What's it now?
I have thoughts, not only because I've been a civil participant in litigation for 30-some years. It seems to be in fairness and due process, you get your discovery before you have to make a decision on summary judgment. And since you've had discovery held in abeyance by the Court of Common Pleas, it seems to me that these should be granted and discovery completed before we go on summary judgment. I'm not discussing the merits of it. I think there are merits to it, but I think the party is entitled to complete discovery before they actually have a ruling upon it.
And I would agree with that position. A lot of my litigation's been at the criminal level, but I have significant civil as well, and you're right, usually the discovery is completed before motions for summary judgment are filed in active form. It's kind
I think.
of- You're civil.
I was just saying, no, I
Don't disappoint us, please.
I don't disagree. I mean, it's just, from my perspective, it's really not any kind of a predetermination on the merits. I think that there are merits issues that remain. They may be appropriate for somebody judgment. I'm troubled by, the lack of discovery through, honestly, no really fault of the parties. They're going through the process. They're doing what they're supposed to do. They're being held in abeyance while they're waiting for a judicial determination. So I don't cast any fault or blame on the parties on that. You're doing what you can. I think to speak with the Attorney General again and have the suggest to the court that have been holding up our proceedings. This issue would be nice. They could do that lightly, I believe. I have been in that position in my career on more than one occasion. It's about top.
It's better today's day and age when they have staff attorneys.
It is better, and it can be done. So I think it should be, I think that the commission should take some kind of a proactive role to let them know. Sometimes the court's just not aware that it's holding everybody in suspension and maybe making that issue apparent to the court. So I'm in agreement. I think that I appreciate the party's position in this. I know you have other litigation. I appreciate the arguments of discovery that could have been taken in the other litigation and used here. That's typically a little bit outside the civil process. You would expect your discovery to be in the case that's pending. And so, you know, and I know other discovery could have been taken, but parties and their lawyers can choose how they want to proceed on discovery. So at this point in time, I'm in agreement with with Mr. Munn and Mr. Price that it's just not that it would never be appropriate for summary judgment, because I do agree with Mr. Klamer, it's something important on this. But at this moment in the proceedings, it's not appropriate.
Thank you.
Yeah, I want to jump, I understand that once you get to the stage, you are not those with the. But if that's the issue, it's fine. One of the things that the author to help move this process along, is that Mr. Stafford would be willing to just not be staying on social media, that he would leave all of our other arguments on the hill and we can move forward with discovery.
Isn't that the exact issue that's pending?
Is the question of whether or not he's going on social media?
Isn't that the pending in your appeal?
So, well, Mr. Klinger has indicated that there are other issues, and my point is I'm more willing to waive any of these other issues that they could leave out there. They're not supposed to the discovery until you.
Mr. Clement, in response to that.
I mean, they're asking my client to agree if they're right from the outset. I disagree. We filed a motion for, they filed a motion to check order, we opposed it, but which is fine with us. and my client had them. And then I could talk about this, talk about, especially a matter of public interest like this. And so I, no, we're not ready to make that agreement.
Okay, that's fine.
That is all.
Oh,
Great.
thank you.
Appreciate that.
All right, so
Appreciate both sides.
is anybody else, I want to make sure every commission member has an opportunity to say something.
All I have to do is, yeah. That's all I want to know.
Should feel appreciated.
Yeah. All right, anybody else? All right.
Well, I'd just say my,
Go ahead, sir.
not being an attorney, I have to conclude also that the motion for summary judgment in this case has been premature. I've lived through a number of levies, and I understand the role of superintendents, and I know your job is to sell it. And I've got communications in the mail from superintendents. I attended meetings where the superintendents got up and pled their case, quite frankly, as to why the school district needed to let them pass. So I get that. But nonetheless, and again, my vote in this would not be an indication of my position on the merits of the charge against Dr. Kozak, but I just think it's premature.
All right, do we have a motion?
I move that we stay proceedings in this ruling on a motion for summary judgment until such time as the parties have had to complete their discovery, and this matter is actually set for a hearing.
Thank you, sir. Do we have a second?
Second.
Discussion on the motion? All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Thank you very much. Thank you, council. Appreciate it.
And it's business.
Yeah.
Thank you very much.
I thought so.
Can't do that anymore. I almost did it. I was doing it even though I wasn't voting, so I was very active.
That's like, what do they say, it was how long, 21 days to make, and now it's back to like.
Yeah, a year. A year.
Okay, that concludes that portion of the agenda. Under other business, Mr. Richter, I know we have next meeting is August 12th, 2021. Anything else that you'd like to share with us?
Well, I've got a couple of notes there as it relates to personal items. Thank you for everybody's consideration concerning my father-in-law's passing yesterday. I'm presuming I'm gonna leave here in a little bit. I got a few things to do before I go. Maybe they can talk to me very, very well. But I'm anticipating going back down to Cincinnati, being down there. My wife and my mother-in-law at this point are tentatively scheduled to meet with the funeral home at like 2 o'clock. I don't know that I'll take that, but they're working through the process. I won't go into in great detail, but my father-in-law's memory was fading. And while obviously it's difficult at another level, it's a blessing.
How old was he?
He's 7. And so, it is what it is. My mother-in-law's doing as good as you can do under that set of circumstances, and so is my wife. So, number 2, we were planning on taking a hiking trip starting next Friday. We'll see if that goes forward or not.
It'd be good for you.
It could, and I even said something to my wife last night, in terms of planning the events of all that, going around this. I said, we want to rethink that, and even my wife last night was like, no, it's not this one. So we'll see how that works out. Tuesday, I'm scheduled to do a CLE in Richfield. I've done these for a long time.
Where at Richfield?
There's
It's about 5 minutes from where I live.
Because once you go, once you go into an evaluation.
Yeah, maybe do an evaluation.
Evaluation for number 4.
That's okay.
There is a, right after you get off, you go up as 77, or you go up from 270. The very first exit, there's like a little hotel conference center there. I want to say it's Days Inn, but I don't think that's right.
I don't know what it is anymore.
It's right there.
Yeah.
It's right there. And I've been doing these for probably about 10 years or so.
I heard the man was so high, it's gonna be at the Richfield Coliseum.
Well, you know, it's always a possibility, pack them into the gills there.
And that nice empty field.
Now,
The Coliseum still exists.
What time would that be? No, it doesn't.
the actual, yeah, the CLE starts at like 9. I think I'm normally scheduled right around lunchtime, so I can put people to sleep. Right before everybody goes to lunch. They're actually, I mean, they're very, very informative, because they'll have somebody from the Secretary of State's office talking about, you know, kind of what's going on there. They have somebody from the Election Association talking about elections in general. They'll have somebody doing their kind of what's going on in legal circumstances. There's a lady from the Mahoney County Prosecutor's Office that does that. She's been doing that for a number of years. And then I get to do about my 45 minutes or an hour on the Elections Commission, et cetera. So it can be very informative. We can, Mr. Kreitz and I discussed doing an interview with me, or doing a review. We can do an interview too.
Or intervention.
He asked me to inquire about certain other executive directors and whether they get written evaluations. I've only talked to one, but it's a very similar position of mine. He was indicating that neither he nor any one of the predecessors ever had a written review. But, so I don't know how that impacts you guys, but there it is. So that's all of my personal notes. As it relates to the commission, we had a couple of the decisions appealed. The Henshin case, which was Bud Henshin was the guy who did McTighe filed the independent expenditures report on his behalf that needs to remain anonymous. And the Wood County Board of Elections referred him to the report, list himself going over the statutory expenditure level for an independent expenditure issue. We found a violation of good cause. Originally, I talked to Mr. McTighe about this a long time ago, and he was talking about, he figured what we would fund, or, he obviously argued against it. But was at one point anticipating appealing on First Amendment grounds, in terms of with a right to remain anonymous, in the statute does not include a disclaimer. How could there be an obligation to file an independent expenditures report that teaches you to be anonymous? He had lessened his desire to pursue that avenue, but he may still do it there. But the other primary thing he's appealing is our decision, and I believe rightly so, said that no, you have to file a full complete report, and that is a body report. If you don't, you certainly may have an ability to cure it, but you have an obligation to file it correctly initially. Part of the argument that Mr. McTighe made in the call is 351711 allows for a 21-day period to amend your report, and that he had argued that Mr. Henshin did not take that 21 days, and that was the primary reason that's statutory effect. And, I think we will certainly challenge that broadly and strongly, but if the judge makes such a decision, okay, the judge will have his opportunity to speak and make that decision. I didn't believe that it was appropriate for the Elections Commission to make that, to make that kind of, I believe strongly in the decision that we made. So that's where that stands.
Is that or the county conflict?
The other case that was appealed, the Raleigh case, Protect Geauga Parks. It was actually heard on the same day. They had a hearing on that matter. It ended up finding no violation in the allegation that they shouldn't have been able to hack. The attorney from Mr. Raleigh filed a complaint. I kept waiting for the press feed on it, or someone on it. Never did get it. Then I looked in the case and found out why. You weren't listed as one of the parties. He filed his appeal of our decision against Protect Geauga Parks. The commission.
Well, that's a different way around the system.
It is. So I have been I have been trying for days now to get the entire transcript submitted. I've gotten about 95% submitted because for some reason, the e-filing system wasn't accepting the transcripts. They had the court reporter provided repeatedly. Well, but if you heard my phone ding earlier, that was the court of comment, that was the technical staff at the e-filing system finally calling back to the resolution 4 days later. They were telling me that my file was corrupted, and they just gave me these files back. I was looking at like, go. So I think upstairs, I will try and do some of those. And then the full records considered. I talked to counsel, Ms. Scheitzel, who's representing chief of the file motion to dismiss. I think we were both the right party. So that one should go well. So we have announcements, we care that I don't know. No, but they just said that, I'm sorry to say. And then the mandamus, the may be sued by a mandamus action is, Mr. Borges's attorney in the household matter has requested that he was issued to a gentleman by the name of Mr. Berg.
Mr. Schneider?
No, well, yeah, he and Mr. Wong, both. It's been more long only because when I responded to them yesterday, I got an email response back that Mr. Schrader's been out of the office for the last 2 weeks, returning today. So that's why Mr. Schrader, because Mr. Schrader previously contacted me.
Is it Tom Long?
Podwell. I denied I denied their request for subpoena because he's not issued subpoena for the preliminary review. We never have.
Before doing so, I just asked the record, like, that I'm not participating in any way in the discussion with respect to us over or this matter.
Considering they were indicating that they may file a mandamus action, I was in touch with the Attorney General's office, because they would represent us for the action, and I'm still anticipating that they would do so. But I worked back and forth with them to come up with a response to them, to essentially say, "Sorry, I'm not going to issue those subpoenas." I sent that back to them yesterday. We'll see if they file a mandamus action. I believe that I have an appropriate position. If not issuing subpoenas, part of it is based on, during the preliminary review phase, we can decide, hey, this is a finding violation, whatever, or we can set it for hearing. And so, as long as we are still in the preliminary review phase, which we are, for that particular matter, it's possible that we could go back to the preliminary review phase and dismiss it, or find a violation, at which point it would be useless to have. So we have witness had some sort of definition. And our rules don't necessarily allow for subpoena during the review phase, specifically with the rules in the hearing phase. And so that's the primary reason back, but I wouldn't be surprised if they still try to do this. The AG's office and I work together and they're comfortable with my approach. They've asked whether this is a position that I want to go forward and do. And so that's where we are. So there's the updates that I have on other.
How do we want to go ahead and do the evaluation of Mr. Richter? The intervention and discuss. Go ahead. Executive session.
Yes.
And I have to make an oral discussion on performance and things of that nature. This is a CB in written form. It's been 2 years. I don't want to drag it out. I think it's important to do it. So
I think we should do it at such a time that we have all the information from the audit. Do you have that?
No, we're in the process. I've been, honestly, that I don't know the answer to. I'll be honest with you, I've been a little slow getting back to the person doing the audit, dealing with a lot of the other things. Partial explanation.
I think Scott's point's really good.
But
I just don't, I want to drag this thing out. It's been 2 years. Remember, we talked about, we had a reason last year because of the pandemic. 2 years ago, when we discussed it, and Captain was the chair at that time. And we kind of all said, look, we need to do this on a regular basis, on an annual basis, so. I can let it slip a couple months, I think, if that's what we have to, but I don't want it to slip much beyond that. The audit's not done, I guess we.
Yeah, I mean, it's one of those things
You check
where
on, and
well, it's a matter of us getting back to them first.
Yeah.
But then it's also a matter of them producing it and getting it to us. And, you know, in other times, it has been promptly submitted to us after they complete it. The last time, we didn't get the audit until almost a year later, as I recall. I could go back and look to see exactly when we done it. But, you know, it's done every 2 years, et cetera. And for there, they didn't really have as I recall, they didn't have an explanation beyond the fact that it took them that long to get it done, the last time. You know, so I don't know when we would get it. I'm not trying to be evasive, it's just I don't know the answer.
If it took a year last time, I suspect I'm gonna have a post-pandemic, it's gonna be equally long. I just saw on the paper this morning where if you want to get your passport, they're now 12 to 16 weeks out. Yeah.
Well, alternatively, I would say in their defense, having it been relatively slowly done the last time, they may want to use it. Yeah, I don't know the answer to that, but that's.
what's our schedule look like in September? Can we just set it down tentatively for one of those 2 days?
There isn't anything that much, you know, there isn't that would keep us from here to get either of them.
Well, we had 2 meetings, I think, in September. Let's do the second one. Let's set a schedule for that.
Okay.
Can you do us the pleasure of circulating the previous audit then so we have that to review and everything else?
Oh, yeah. Oh,
And then September 9 and September 23.
yeah. Okay.
Is it 23rd on folks?
Oh, sure. Yeah, okay.
Because, so, how do you request this audit? I mean, you just call them and say,
No, we don't request.
They request it when it occurs.
It's automatic. The auditor's office is obligated to do a biennial audit of all government agencies.
Pretty well.
You know, and so,
so what you'd be doing in this case is reaching out to them and say, please, conduct the audit.
no.
You're not.
No, they reach out to me. I don't know whether they did it in January or February of this year, starting the process that says, okay, you know, we're going to be coming to the audit. We're going to provide these things, and we're going to be asking for these things. We provided certain information, so far as other information you need to provide. It goes for the rest of that fiscal year. And then now that we're in the next fiscal year, then part of what they do is do, you know, a resolution of that considers up to June 30. And then they have their 2-year audit. So, you know, and different agencies are done at different times. Ours happens to coincide with the state's fiscal year as well, but I don't do anything. They come to me and say, okay, we're about to do the audit, be ready.
And just come.
Yep.
Examine our rules. And policies and procedures.
Correct.
Okay.
So there we go.
One last thing I had for, while we're on the record, we,
Are we on the record?
are we,
Yeah, come on.
oh, okay, maybe we weren't on the record.
We were.
It doesn't
We were
matter.
so much.
I just have a question. I was thinking about this the last couple of days. All the months that we were virtual, we really had a hybrid system. Bill would invite commissioners who live around here and people who might have interest in a case to come here, while the rest of us were virtual. Is there any way that we could do that as a, because I know other agencies are doing that. They're doing both. They're doing in person and they're doing virtual at the same time. And I maybe this is more directly to you, Chris, because what would have to be done to make that happen with this commission?
With authorization.
Well,
I mean, you're,
I don't know.
hold on, I did want to say this, now, that you're saying other agencies are doing it, so since the order has expired, other agencies are doing this, when did the order expire?
June 30th. No, June 30th, at the end of the fiscal year.
Okay,
So you're saying, you'd be saying, I guess, no state
agencies or commissions are doing a hybrid version.
Well, I think that you're asking two different questions.
Right.
Maybe. One is the question of whether or not the commission could have some people remote and some people not. I think the answer to that is no, that commissioners have to be present. Conduct a public meeting, and if you are remote, at least my understanding of the section was nobody could be remote after meeting here.
Correct.
On the commission. Whether or not a participant could, a respondent or a complainant could appear remotely when we are all here together. I don't know that that's the same question. And I don't know the answer to that. And courts do it all the time, but they're not subject to the same rules as we are.
Yeah, I agree with you. We did a little bit of research on that first issue about whether or not we could go hybrid in connection with one of our municipal clients. And we concluded that pretty much the way the language read, didn't read in the budget bill on this past, we could just make it being in person.
Right.
Yeah.
For the group.
For the group, yeah, for
Now-
the commission, the board members. the
Right.
council. Yeah,
Agreed.
but you're right, and I don't know the answer to the second one.
Well,
Actually,
Yeah, it has always been my belief that in order to, and don't answer this on chapter and verse, but I believe that, the sunshine law statutes obligate not only members have to be present. That's the constitutional and statutory, but I believe anyone who wishes to address a body, an agency such as ours has to be physically present as well. I didn't necessarily share with all you because it kept going back and forth. We had conversation about coming back here, but I had actually had a conversation with Ron Bryant, former prosecutor. Yeah, who he is on the Liquor Control Commission. But he had indicated to me that, and I believe it was the counsel for that body had seen some things in the budget that was potentially going to extend an ability to meet remotely till the end of the year. And I asked him to provide me with that information, and he provided me with, I guess, the outline of their memo on that. It made cross references to various sections in the budget bill. Whenever I looked in for those sections, and the copy of the budget bill that I became privy to, I couldn't find anything like that.
I asked for a lobbyist and they said it wasn't in there.
And what happened, and then later on, Mr. O'Brien shared with me a subsequent memo. I said, look, he shared with me the LSC analysis of the final budget bill, and what it showed was in the originally submitted House budget bill, there was a provision that would have allowed continuation of remote meetings to December 31. That was passed out of the House because it said provision in there. What came out of the Senate, though, if you look at the LSC analysis, and I can share it with you, because you've had that from Ron sitting along, it says no provision as it related to that. And then what came out of conference committee also said no provision. So it was taken out by the Senate. After they went into conference committee, it was taken out. And so even Ron had to come back to me and say, yeah, we're kind of meeting in person from now on. And so that's always, I'm willing to look into whether individuals, like, Mr. Klinger, Ms. Justice have to appear. It's always been my belief and my interpretation of the statute that in order to address, obviously you guys want to be present, but in order to address a body, you also have to be physically present in order to do so. That's always been my understanding. And so I'll double check and look into it further, but that's kind of where I'm coming.
Yeah, that was more my direction. When I thought last meeting, when we had so many people from Cuyahoga County, we have them from Summit County, we have them. And I just wondered, is there a way that they can address us remotely and have a
Well,
hybrid?
I would say, okay, this is more from a practical standpoint. Even if that was to be the case, in my view, under the technology that the state is using right now, okay, that platform or that way of doing it or whatever, it is not good. I mean, there's a different way, there's maybe a different way of doing it where, you know, this person comes in.
I just like how it's said.
The way we had it was cumbersome, we're getting noise from other people and all that, wherever, if we're dealing with one case, one person, or one set of witnesses or something like that, that's a whole nother story.
Right.
But the way that we have it now, we have all those people on there, we're waiting, we're trying to find and who's on, who's off and all that. It's just not practical.
Right.
In my.
Right. Well,
I have to say, Autumn, you just said what everyone believes about teams. I mean, that is not the best format.
But also to that, don't you think that, I think there are a lot of people that came on and said, thank you for your decision, that maybe would not have made the trip from Cleveland or wherever.
I agree with that.
You know what I mean? So I think it kind of would weed out a little bit of, you know, to your point, like not having 35 people waiting in the lobby. So, you know, from that aspect.
You just won't have 35 people. I said this, the one thing that's nice about it is you got people to have their say,
Right.
have their voice heard.
Well, and understand what to do, some of them are just at a loss of how do I fix this?
Right.
I'm a novice, there's a lot of things going on.
So they actually got a voice during that time that they might not have got.
I agree.
I appreciate that.
well, you know, it didn't go anywhere that I expected it to, but, I was approached by a council to speak at one point on some other issues. I think I briefly talked with you on the possibility of, you know, on all electric filing system, which haven't done anything on since we originally met those folks in North Carolina, but, you know, we'll continue to follow up on it. But in my conversation with her, I did say, you know, we found having remote meetings has been pretty beneficial. Obviously, somewhat to you guys, but more in terms of reaching out and allowing persons all public like that. You know, I would certainly be in favor of it. And then I think I indicated everybody, when I did my House budget testimony, one of the reps, one of the state representatives who was present at my budget testimony, did ask about how it was going at the time. And that was in February. And it was in February when I addressed the House committee. And I said to her, you know, we have found that it increases the amount of participation, you know, in terms of the persons out there, and then it has been beneficial in that regard, you know, but obviously that had any real influence on the Senate side, and I wasn't asked that question for it, but the Senate budget testimony. So obviously, you know, those provisions came out. I think it's people guys in person.
You like it?
Like it.
It's good to see everybody. And Mr. Norman has to put his pants on.
But he should.
All right, is there anything else, Mr. Ritter?
No, nothing else that has been published on our agenda, Mr. Chairman.
Move to adjourn.
Second.
All in favor of the motion to adjourn, say aye.
Aye.
Force of habit.
Yes, that's, you know, your reason.
Motion carries. Thank you.
Good seeing everybody. Safe travels back.
Just put what's on.
Don't keep going.
Pretty
Yes, I
good.
would definitely do so. Again, thank you.
I think we're there.
Yeah, so I did
Did
this.
Steve wear it here?
Not bad.
Oh, here's like. Right, oh, yeah.
4 years now. I've been driving.